to this session on emerging international law. I will try not to take valuable time from the speakers who are much more knowledgeable than I am in these topics. So I'll introduce all the speakers and the topics that they will focus on in their presentations. Each of the speakers will have 15 to 20 minutes for their presentation. And then we will take two questions related directly to a particular presentation, which should leave us with some time after all of the presentations where you can ask broader questions to multiple speakers at once. The first topic of this session is the influence that strategic reality has on the development of international law. This is a timeless question which many legal scholars have grappled with in the past. The most radical critics going so far as to say that international law is not law at all if might comes before right. And Sean Canuck will take a look at the interaction of strategy and law with respect to cyberspace. Sean is an affiliate at the Stanford University Center for International Security and Cooperation. He serves as the chair of the Research Advisory Group of the Global Commission on the Stability of Cyberspace, and he is a member of the International Institute for Strategic Studies. And he previously served as the first U.S. National Intelligence Officer for cyber issues from 2011 to 2016. So, Sean, the floor is yours.
I'm going to start by asking you all, first of all, thank you very much to CyCon for inviting me. It's a pleasure to be here and a chance to address you all. I am unfortunately in pretty poor health today, so I ask you to indulge me and understand that I'm going to give a little bit of an abbreviated presentation to make sure I hit the key points I wanted to. And if I end up needing to excuse myself before the full question period, please forgive me. But I didn't want to cancel because so many of us has come from so far away. So thank you for the introduction. I am an international lawyer by training, a strategic intelligence analyst by profession, and a student of military history by hobby. That's the perspective I'm going to be talking to you from today, and exactly as our moderator laid out, I'm going to touch on the legal aspects, but I'm going to come at it from a strategic reality perspective. What I have up here, each year, the U.S. Director of National Intelligence, on behalf of the intelligence community, does a worldwide threat briefing to the United States Congress. There's a classified version and an unclassified. These are excerpts from the publicly available unclassified version. You can find the whole text on the internet. In 2016, early 2016, this is what we wrote when I was the last one of the worldwide threat assessments done under my tenure. Clearly, the top sentence is referring to the fact that deterrence isn't working in cyberspace. And the second aspect is about what progress are we making on the legal side. Now, the document is not a legal one, but obviously the GGE discussions, the tripartite strategic interactions between the United States, China, Russia, as well as many other bilateral and multilateral discussions matter because they're happening at the strategic security level, they're happening at the political level, they're happening at the economic level, and they're happening at the legal level. And one of the things I found in my old job was that some of these discussions seem to be completely ignorant of each other, or if you're a little more less kind, intentionally misleading in certain of the fora when they're doing different things in another fora. And we'll get into what I'm talking about. But I wanted to start with that because it'll put us in context for where I want to start. Law is reactive to technology and politics. Law in general is a conservative discipline in society that institutionalizes politics from yesterday and public opinion from the past as well. It's the way we institute our civic ideals, our societal values. So it is very rarely the absolute vanguard. It's usually responding to technological developments and looking at real cases of controversy that already exist, or giving advisory opinions on things that are anticipated to be problems in the future. Strategic reality, in my opinion, is what drives a lot of legal development at the domestic level and absolutely at the international level. A couple historical examples, okay? Those of you who are fans of the law of the sea and the various territorial waters and the high seas portion. If you go back several centuries, the territorial water concept was linked to what they called the cannon shot rule. It was how far a coastal artillery battery could effectively control the territorial water. Back then, it was at about a 3-mile range, 1 league, right? With time, cannons could shoot farther, and the law developed and outran that old cannon shot rule into what we now see as the law of the sea. But it started with a strategic reality in Grotius's time. Outer space laws. Those developed during the Cold War period. And if you want to talk about the delineating line between territorial airspace and the commons of outer space, or you want to understand why territorial airspace was militarized and controlled, but outer space was meant to be demilitarized and the common heritage of mankind, that's because the United States and the Soviet Union both wanted to do overflight of each other's nations at a certain altitude for confidence-building measures regarding nuclear arsenals. Space law develops out of the national security reality of the nuclear era arms race. We can even talk about more specific things that are akin to Hague law means and methods of warfare limitations. How many of you know that back in the 11th and 12th century, Popes Urban and Innocent were outlawing the crossbow? Okay? Because it was inhumane and inappropriate, unchivalrous. What's the real reason you didn't want a crossbow? Because you could take any peasant and in about 3 hours train them to kill an aristocrat mounted knight. That's why the powers that be got the Pope to outlaw the crossbow. Now, eventually, the military reality wins the day and crossbows continue. St. Petersburg Declaration of 1868. Familiar with that one? One of the original documents in international humanitarian law. Prohibition on the use of exploding projectiles below 400 grams. St. Petersburg Declaration gives you a hint of which sovereign called for that meeting that led to that document. It was the Russian Tsar. And these projectiles that were small and exploding were incredibly effective at destroying munitions wagons. They were wonderfully effective as a technology, and both those munitions and later on the expanding bullets that we see prohibited in the 1899 Hague Convention, known as dum-dum bullets because the British Empire was able to produce them at low cost and in mass volume in a factory near Calcutta in Dum-Dum, India. These were incredibly effective munitions that people sought to limit their use at a strategic level in addition to the publicly given humanitarian rationale. So I give you that little bit of a history lesson to then ask ourselves, what is the strategic context within which the diplomatic and legal discussions about cyber law are occurring? A couple of the presentations yesterday that I saw quoted the fact that 30 plus, it's above that, but that's a conservative number, nations are preparing offensive capabilities for espionage and warfare. They're using these capabilities in peacetime and in wartime. To my knowledge, no country has sincerely brought forward a concrete proposal to outlaw any specific type of cyber exploit or type of cyber operation. There have been discussions in the GGE and discussions in other legal scholar areas about nations who want to limit the targets, when these tools can be used, against whom they can be used. That means we're talking about the corpus of law that we usually call Geneva law, rather than the corpus of law that we call Hague law, which says thou shalt not use poison gas in an international armed conflict, or you shouldn't do certain kinds of aerial bombardment. Last point up there, civilian entities are enablers and targets. This is another real thorn in our side for some of the basic principles that we hold dear. The civilian combatant distinction, proportionality. What happens when a private company has created the tool, or weapon as some like to call it, may be working in concert with or towards shared ends and objectives with one or more nation states, And what happens when those companies, and we heard Microsoft talking about it in their presentations, feel they are actually the target in the crosshairs of international armed conflicts or international political disputes? Think about what the endeavor from 1945 on was under Geneva law. It was to protect civilians and delineate as well as we could. If you look at Additional Protocol 2, isn't there a proposed requirement that you have to separate your military and your civilian networks? Anyone in the room from a country that still has completely dedicated government and military fiber optic networks that are not also used for civilian purposes? The United States doesn't. Cost-saving measures, economics, we've crossed that Rubicon, and I don't think economically any of our countries are going back. So we are stuck with a situation where these things that our society for economics, social, education, recreation, rely on the very same systems that will be military objectives in a time of war. I'm a strategic analyst, so I'll give you 1 minute on where I see cyber threats and conflicts going in the future. The main trends, and this is kind of a little cheeky way, when I wrote down the words that I thought applied, they all happen to start with the two letters IN, so that's my little mnemonic for remembering them. Intervention. We talk a lot about international humanitarian law, which obviously applies when there are international armed conflicts. What we're seeing in the analytic and strategy world is most nation states are using them below the threshold of armed conflict, use of force, active aggression, intentionally using coercive measures to achieve political ends, but not crossing that threshold. That is the strategic appeal of these capabilities. Secondly, industry and infrastructure. This is that civilian aspect I was talking about. They are becoming the key players. You can't go after the Federal Reserve of the United States because it may be well protected. So instead, you DDoS a series of 20 commercial financial institutions in an effort to send your political message. We see this happening in a lot of different areas. Ukrainian power grids, civilian electric companies affected. I see that civilian involvement blurring and becoming a strategic concern as well as legal concern. Indirect. This makes the problem even more complicated because in many cases, like with that banking example I gave you, if you can't get at your primary target, well, maybe you can go up or downstream or horizontally in the business sector or cross-sectoral to cause harm that will affect the entity you want. Let's give an example. Financial institutions, incredibly dependent on both electric power and telecommunications. Maybe the bank is very well defended in cyberspace, but maybe its power supply in the regional utility is not, or maybe you can cut a fiber optic ring somewhere. Hopefully they have redundancy, but things happen, right? We know at the very beginning of World War I, what was one of the first actions the British military took? Cutting Germany's undersea telegraph cables. It's how you start a conflict, is go after the command and control of your adversary. And then integrity of information. It's about the value of the information that's transiting the infrastructure pipes. Who can exploit it to their advantage? Whether you're a CEO, a combatant commander, or a head of state, that's your objective, is to get value out of the information. I heard an interesting discussion in the law track in this room yesterday where there was a discussion about the Tallinn Manual commentators and others looking at data or code as an object and as a military target, and one of the commentators was making an argument to distinguish between functional code like an operating system or data, right? Well, what about if that data actually induces behavior? Okay? For me, when I think about integrity of information, I quickly go to Additional Protocol 1, Articles 37 and 39, thinking about perfidy and ruse. What am I allowed to do to your data to induce human behavior that's a ruse because I'm not relying on falsely claiming a protected status versus something that crosses that line and causes you, can I go onto the media and tweet or broadcast that your leader has told you hostilities are over, lay down your weapons? Under normal terms, that would be perfidy. And one of the interesting things, again, I come from the strategic reality side, if you read some of the very sophisticated Russian scholars, like Anatoly Streltsov or Sergei Kamov, they've put articles in Unidir's periodical about perfidy and supply chain attacks. This is some of the way some of our counterparts in the UN Security Council and in our bilateral meetings, they approach these issues somewhat differently than we do. We meaning whether it's the United States or NATO or the Tallinn Manual scholars. Many of us are coming from a Western approach, and most of our interlocutors and some of our adversarial interlocutors have very different frameworks, again, but based in strategic reality. So what do we do from the law side? Probably familiar with the sources of international law from the statute of the ICJ. Well, let's take them in order. A, international conventions. Do we have an effective treaty? The GGE delegates have said that the UN Charter and international law, ambiguously undefined, apply in cyberspace, but we know they're all grappling with the interpretation of that and the question of how does it apply? No consensus there yet, and if you believe the US and some of the Europeans, no treaty forthcoming anytime in the near future, despite the fact that Russia has been seeking a treaty since 1998, a lex specialis on this topic. B, international custom, state practice, opinio juris, what's actually happening. I'm going to come to that a little more because to me that's what's most interesting. And of course we have the other two, and I for one would say that the Tallinn Manual would fall under category D, our jurists, our international scholars. But are you also reading the PLA literature from their equivalents of judge advocate generals? Are you reading what the Russian military is putting out in their doctrinal understandings and interpretations? So, the emerging law of cyber conflict, what are we observing? Play a little game with me here. Without saying a name of a country or an event, who here thinks that any state actor has committed a cyber attack on another nation's assets? We're in Estonia. Come on, I expect a few hands on that one. Second question. Whatever you were thinking, and don't say it out loud what you were thinking about, raise your hand if you think the country that perpetrated it did it overtly and took credit for that military action. I see one hand in the back, okay? I can think of one where I'd say maybe as well. Third question. For all of you who put a hand up saying states have done malicious things and kept your hand down saying they haven't done it overtly, how many think that that state who did it and pretended they didn't ever got effectively punished for doing it? I can think of some minor sanctions. I can think of economic sanctions on 12 North Korean entities after the Sony Pictures Entertainment. Do I think any of those 12 entities were ever going to be doing a dollar-denominated transaction anyway? No. So what have you told us? If I'm listening to you, and it's consistent with my views, I think the customary norm is do it, pretend you did it or lie about it, and you'll probably get away with it and be able to do it again another day. I offer that as the state practice norm that's occurring. When I read the articles and great pieces in the published volume by my two co-panelists, I encourage you to read them both. The first one, well, first of all, I've been talking about state sovereignty, which is what Peter clearly talks about in some of his analysis. So we're kindred in looking to state practice as a formative, emergent source of these legal principles. And then Kubo, in his piece, in his first section, talks about why is the discussion shifting a little bit from law of armed conflict to these other international law principles of sovereignty, non-intervention, state responsibility. Well, you've already heard me invoke a few of those concepts because they're part of the strategic reality. They also happen to be the way that Russia and China frame the entire discussion. So there's a fundamental difference in how the West and some of our Eastern counterparts approach these issues philosophically and doctrinally. China wants to have the discussion about sovereignty and state responsibility. They want it to be an obligation of every sovereign nation to prevent the emanation of harmful information content from within that sovereign jurisdiction. They will gladly take on the responsibility for preventing Tibetan Dalai Lama and Falun Gong nefarious information from spreading outside of China, and they would really like to see other nations do similar things. Who do you find as terrorists? Who do you define as your adversary? Those are political decisions in many countries. But if you're trying to find an international norm or rule, you're not all going to agree who should be on that list. Should it be Al-Qaeda? Should it be Chechen separatists? Should it be Falun Gong? That list looks very different depending on who you ask to make it, which is why if you invoke sovereignty and state responsibility and make it a national-centric authority and rule, some of our counterparts are very excited about seeing that be the prevailing way of studying these issues. Agreed norms being honored in the breach. Most of you, if not all, have probably read the GGE report from 2013 and 2015. On a rainy day, I sometimes enjoyed pulling that out, reading through it by paragraph, thinking about recent cyber incidents that are attributable to nation states, and checking if those nation states had signed that document. In most cases, the answer is yes. What are we doing? Are we talking in Geneva and doing very different things in our cyber commands and in our security services around the world? Where's the reality check? So I see a few key tensions. Dual-use infrastructures. Again, the Tallinn Manual talks about this, and some of the other speakers have talked about this. Talked about cable cutting, the telecom backhaul. Social media platforms. Is Twitter a legitimate military target when the commander-in-chief of the United States military uses it as a broadcast messaging system? My answer in my legal scholarship would be absolutely yes. Opinion jurists versus clandestine state practice. Are we getting declaratory statements from foreign ministries that are not consistent with what their military is doing and denying? And then if you're charged with determining the development of customary international law, which do you give more weight to? I tend to look at deeds more than words. That's sort of my personal life philosophy, but there could be different scholarly arguments there. And then, as a strategist, the lack of enforceable norms, in my mind, leads to further insecurity and pushes this vicious cycle even further. So I would personally love to see customary law develop in a way that starts by looking at common concerns, the real common strategic concern, like what led to the non-militarization of satellites in space in the Cold War. There was a shared interest between the two nuclear powers. Then, of course, address those practical fears. What is law really about at the end of the day? It's about certainty and predictability. You love commercial law because you know how your transactions will be judged. You love international law because you know what privileged status you can expect if you're a soldier or a civilian. And then finally, I think a key factor in all of this is not only publicly attributing those transgressions that we were raising and lowering our hands about, but publicly punishing, preferably in my mind, with an overt cyber operation to get some of this out from the dark and above the table, because that's how I think law will develop in synchronicity with strategic reality. Thank you.
So I think we have time for 2 questions from co-panelists or from the audience. So,
come on, you can't all agree with everything I said.
I have a question for Sean.
Please.
So we were talking about before the panel about this, where a state publicly states something, but there could be more sort of top secret evidence that, for example, in the attribution space, that shows actual attribution, but what's publicly said is different. I mean, where do you see, how do states balance keeping information confidential and secret, and also what you said, publicly attribute and put the onus on the malicious actor?
No, it's a good point. This is exactly what he and I were discussing before the session started, and he talks about this a lot in his piece, and I'm sure he'll cover in your presentation. What states are publicly offering. From a legal development side, all we can deal with is what is offered in the public domain by those sovereign nations. I worked inside the intelligence apparatus in my country. I was in charge of those attribution assessments internally. And I can tell you there were a couple occasions where I got to go down to Congress and say, we have high confidence that. Sony Pictures Entertainment would be one of those, for example. Now, can you get to that high level of certainty, confidence to take a national security response action? without being able to show some effective control or complete direction? I would offer in many cases probably not. The circumstantial stuff is great, but if you are the president of Estonia, is she ready to push a button or launch a military effort based on circumstantial effort? That's for each nation to decide. So I think nation states do that internal balancing of risking revealing sources and methods that would then no longer be available to them with making their case in the public domain. I would offer that to date, in most of the major cases, you haven't had that information put forward by the nation states. In the case where the United States indicted Chinese military officers for intellectual property theft, a private commercial company had already publicized most of that information. So I would offer in the major cases, whether it's the recent Russian activity in the US presidential election or whether it's Sony Pictures Entertainment, we've made the declaratory attribution without giving technical detailed evidence to the public to consider. And of course, Microsoft and others, the Dutch government, the Russian government as well, have proposed some sort of international body to consider that attribution information in a public context. I just think that we're at an impasse in getting to enforceable norms when I see and I've seen this in New York at an East-West Institute event, the US State Department representative and the Russian Foreign Ministry representative side by side claiming the exact opposite fact and citing their own national intelligence sources, which they cannot reveal. How are you going to get a collective norm if that's what you're dealing with?
Russell was first.
Thank you very much for an interesting presentation. I want to pick up on the reference to clandestine state practice. Is it your view, because obviously cyber lends itself very well to covert practice. So for example, in the context of espionage, we hear that, well, states do this all the time and every state's doing it, yet it's done in secret. So can secret state practice contribute towards the formation of customary international law? Or does it necessarily have to be open and public and therefore we can object to it?
So I can offer my opinion, but I will actually start by acknowledging that we have people who spend much more of their professional time in legal scholarship than I do, who have probably thought through this in much more detail. My quick answer would be, if it is reasonably attributable to a nation, and we've seen some private sector companies do very good cybersecurity analysis of things that pretty much point at specific state-sponsored actors, I think if a reasonable person can associate activities with a nation, even if the nation denies it, then I think that might be able to contribute to the deed side of state practice or opinion juris. So I would consider it, if I were an ICJ judge, but you're never going to have to worry about that because I'm not enough of a legal scholar to become one. But that's where I personally would come down. I would be happy to hear any of my colleagues' thoughts.
I think the fact that it's secret, it hurts the second element of developing custom. You could have the state practice, but the opinion of juris, if it's secret and they're not acknowledging it, you're going to miss that second element. So I think the court, the ICJ, would look at that and say, by missing that element, that's not going to satisfy 38(1)(b).
So just a quick, is that okay if I quickly follow up on that? I mean, the whole rationale of custom is that a state puts a legal claim forward and other states say, well, we either accept it or we reject it, or we become a persistent objector to that rule. So for me, by very definition, it's absolutely essential and integral to the whole framework of customary international law that state practice has to be committed publicly. So when we see states taking cover under cyber to do, for example, espionage goes to cyber espionage or attacks goes to cyber attacks, and the list is endless, then it's extremely difficult to look at that practice and say that it contributes towards the formation of customary international law. Yet, in my final point, we see lots of scholars, lots of commentators more generally say, well, we know states do this all the time in the cyber sphere, and therefore, ergo, it must be customary status or contribute towards interpretation of treaties. And I find that extremely difficult and problematic.
If I may just jump in with a quick comment. I mean, I think we need to distinguish state silence and denials on part of states. And so if a state denies having done something, we can already infer from that a certain amount of opinio juris. So remember in the ICJ ruling on Nicaragua, the court said that the state claiming an exception from a rule already justifies the existence of that rule. So already a denial can be instructive for us to infer the correct opinio juris from the actions of the state.
Okay, so I think Kubo can continue with the second topic now. It's the influence of IHL on general international law. This influence is hard to deny considering just the global interest in the Tallinn manual process. Kubo wrote a great article on the topic, pointing out that we have to be careful if we want to apply some of the rules of IHL to peacetime cyber activities, or trying to use analogies. Kubo is a senior lecturer in law at the University of Exeter. He holds a PhD from the University of Oxford, and in his teaching and writing, he focuses on the law of cybersecurity, international humanitarian law, and general international law. So, Kubo, the floor is yours.
Thank you very much, Tomasz, and thank you very much to the organizers of CyCon for inviting me back. It's a pleasure to be back in Tallinn. And before I start with the crux of my argument, I actually have a confession to make. The presentation that you're about to hear in this paper, it has a certain personal value to me, perhaps more than ordinary conference presentations. And that's because it mirrors a little bit my development as a scholar. And so when I was doing my PhD a couple of years ago, which was on conflict qualification, so very much using the lens of the law of war, I learned about this new thing called the Tallinn Manual, which was about to be published, so the first Tallinn Manual. And I found it very fascinating, and as those of you who were here yesterday, you've heard that I might have come into a slight disagreement about the question of data as a military objective. So that was my way into this cyber sphere. And I found it fascinating. Of course, we disagreed, but we don't need to revisit that debate from yesterday. But then after I wrote my paper and we had this great debate, there was something that kept bugging me. And I was thinking, maybe we're looking at this problem from the wrong angle. Because if you think about the cyber incidents, you know, the major cyber incidents that affect our lives, that perhaps have had international impact or even have influenced the relationships between states. So, you know, you have already heard them on the panel, on other panels, the DNC hack, the Sony hack, most recently the WannaCry incident. They're all peacetime incidents. They don't imply the use of the wartime lens. And so that made me think, does the law of war, the law of armed conflict, does it really have nothing to offer when it comes to the regulation of cyberspace activities? And so this paper is my way of reconciling a little bit this tension that I felt when I started thinking about these things. But let's begin at the beginning. So there are some principles, some rules, and the sets of these principles and rules, which we could say are at the heart of international law. So they apply to relationships that are governed by international law. So whether we think of, you know, dispute settlement between states, violations of human rights by individuals, of individuals by states, or interactions between states and even non-state actors, even in outer space, all of those are relationships that are governed by international law, and there are some sets of rules and principles that apply to all of those relationships. So sometimes we refer to those as general international law, or because of the theme of the conference, let's call them the core of international law. Now, but that's not all that there is to international law, right? We can think outside of the boundary of the core, and we will find that there are other specific domains and sub-areas of international law that are outside of these boundaries. And, you know, one day I'm going to figure out how exactly big they should be, and depending on the number of the rules in these areas and how far they should be from one another. For now, I'm just going to tell you that the map is not to scale. Yeah, the map is not to scale. But, you know, normally, when we think about the relationship between the core and the periphery, what we think about is how does the core influence the periphery? So we think about it in this centrifugal motion, if you will. So we have the rules on reparation for injury under the law of state responsibility. So how do those affect the specific rules on just satisfaction under international human rights law? Or we think about how we apply the Vienna Convention on the law of treaties to determine, for example, now in the country where I live and work, in the UK, how to determine the exact procedure of Brexit. But there are some exceptions also where this boundary is perhaps firmer than in other situations. And one example is the principle of lex specialis, which is now embodied in Article 55 of the Articles on State Responsibility. But I'm going to leave that for Peter because I know he's going to look at that in more detail. Now, because of these relationships, concerns about fragmentation of international law have appeared some time ago. So in a sense, these are worries that the process of particularization of international law into these separate normative regimes might create potential normative conflicts, normative tension, and perhaps it might undermine the authority of international law, again, to use a favorite phrase now in the UK, as stable, as a strong and stable system, right? So this is why I think it is important and also fascinating to look for the reverse, for the centripetal motion. So cases in which the periphery affected the core. And I would put it to you that the most interesting place where to begin looking at that is the vanishing point of international law, to use Sir Hersch Lauterpacht's famous metaphor, of course, one of the fathers of modern international law, who has described the law of war as being at the vanishing point of international law. So what I'm going to do in the rest of my talk is to explore the three dimensions between the periphery, or this vanishing point of international law, and the core. I'm going to look at the systemic, the conceptual, and the teleological dimensions of this relationship. So let's start with the systemic dimension. Now, whether you want to trace this thought back to Hugo Grotius, who you see on the picture, or even to Cicero and beyond, the traditional view has always been that inter bellum et pacem nihil est medium. In other words, there was a clear distinction between the law of war and the law of peace. So the orthodox view was that there was no status mixtus under international law. Now, in this sense, international legal scrutiny of cyber operations initially emerged and developed through the optics of the law of war, not the law of peace. And this has been the case when it comes to early academic writings about the international law of cyber operations in the 90s, early states' reactions in the 2000s, as well as early compilations of rules applicable to cyber operations after 2010, by which I, of course, mean the first Stalin manual. Now, to some extent, this is understandable. After all, if you think about it, this progression also mirrors the development of the internet, which also started as a military project in the United States. However, this approach has also led to serious concerns about the downsides of applying this so-called military paradigm to international legal regulation of cyberspace. And so these concerns were voiced by several Western academics, but perhaps more importantly, also by non-Western states led by China. And according to these critical views, the key risk of the law of war focus on the regulation of cyberspace was that it would, in the words of Ma Xinmin, a leading Chinese diplomat and international lawyer, quote, that it would aggravate the arms race and militarization of cyberspace. Now, of course, as the ICRC stated in its report to the 32nd International Conference, we've heard a little bit about that yesterday, asserting that IHL applies to cyber warfare is not an encouragement to militarize cyberspace, and it should not in any way be understood as legitimizing cyber warfare. So this is an obvious truth. You know, in the same way, it would be manifestly wrong to say that, I don't know, that to assert that Geneva Conventions apply somehow legitimizes warfare in general. But still, the worries about the creeping militarization of cyberspace cannot just be brushed away that easily. So, on one of the final pages of a book dedicated to a close scrutiny of cyber operations from the perspective of international law, Professor Marco Roschini observed dryly, I'm quoting, "The militarization of cyberspace is not a risk. It is already a fact." Now, at the same time, and this cannot be highlighted enough, most, if not all, cyber operations fall below the threshold of armed conflict or do not occur in the context of an armed conflict, or even if they do occur in the context of an armed conflict, they then fail to be attributable to a state or to bring about a sufficiently serious effect. So as such, the framework of the law of war is actually not applicable to perhaps 99%, perhaps more, of the existing cyber operations. So, and this is what I call the systemic dimension of the relationship. So as the realization that virtually all cyber operations must be analyzed outside of the scope of the so-called military paradigm was spreading across the literature just around the time of the publication of the first Stalin manual, the discourse has shifted. And so academic debate and also state focus have migrated from considering the questions of the law of war to questions of general international law, such as sovereignty, non-intervention, and state responsibility. And I would argue that this has had two main consequences. The first main consequence was that this transition of the debate from one specific area of international law, if you will, at the vanishing point of international law, towards the core, demonstrates that concerns about the law of war claiming full autonomy from general international law may in fact be less salient than some have worried. And then the second consequence is that this systemic shift has allowed for a number of concepts and approaches to migrate also from the law of war towards the core, towards general international law, again alleviating concerns about the supposed fragmentation of international law. So in the next dimension of the relationship, I'm going to look at this particular migratory pattern. So this is the conceptual dimension. Now, on the conceptual level, we may see the potential for certain ideas, concepts, or approaches to migrate from the law of war, or the law of armed conflict, where they had emerged, developed, or consolidated, and into general international law, where they may prove useful and even viable of existing independently. So today I'm just going to focus in the remaining time that I have on one of them as a sort of pars pro toto indication. So one of the key concepts, and we heard about this a little bit yesterday, but for the benefit of those who were not here during the panel yesterday, one of the key concepts that has received a considerable amount of attention under the law of war is the notion of attack, and then specifically cyber attack. So as a starting point, and to put it simply, it is now generally accepted that a cyber operation becomes subject to the law of war regulation of targeting if and when it results in physical damage, destruction, injury, or death. So that much is accepted. And in addition, we have had a very useful debate over the last 10 to 15 years about the relevance of certain potential non-physical effects of cyber operations. And we have focused on that yesterday during the panel. So, if we take the example of Peter's smartphone that I see there on the table in front of him, so suppose that I disable, but I don't destroy it right now using cyber means. Does that qualify as an attack? And so Professor Schmidt, who is sitting in the front row, has described the evolution of the thinking about such operations in his article, Rewired Warfare. On that basis, we know that at this point in time, even the erstwhile proponents of the view requiring the existence of damage seem to accept that mere interference with what is called functionality of a device or network with no immediate tangible physical effects may amount to an attack under the law of war. So, and this is also the view that was eventually endorsed by the international group of experts which produced the Tallinn Manual. Now, crucially, for our present purposes, this functionality-oriented approach towards the definition of a cyber attack seems to be migrating into other areas of international law. So it is directly influencing what we consider as a weapon. And this is a term of both the law of war and the law of arms control and disarmament. Also, because using weapons against a civil aircraft in flight is prohibited under international law, it influences how we interpret international civil aviation law. The test of functionality can also provide sufficient granularity into understanding what type of conduct amounts to interference with a state's sovereignty, which is very much a concept right at the core of international law. So, all in all of this demonstrates the potential for conceptual migration from the periphery, from the vanishing point, if you will, towards the core. In other words, certain conceptual ideas and interpretations that had developed in the context of the law of war may find their usefulness in other areas of international law which lie at the interface with the law of armed conflict. So finally, the last dimension I'm going to look at is the teleological dimension. Now, if you're with me so far, it might feel tempting to look for as many notions and approaches at the interface between the law of war and general international law as we can find. However, I argue that we must not lose sight of the unique teleological underpinning of the law of war, which sets it apart from other disciplines of international law, including general international law. And by this, I mean the fact that the law of war is, in the words of Professor Joram Dinstein, predicated on a subtle equilibrium between the two diametrically opposed stimulants of military necessity and humanitarian considerations. Military necessity and humanitarian considerations. And it is because of this equilibrium unique to the law of war that notions and approaches which developed in its context cannot be automatically transplanted to domains where one or both of the stimulants are absent. And so this is an important warning because some calls for the wholesale adoption of these law of war approaches to making decisions about cyber defense have started cropping up in the literature. And so one of the implications of such proposals is that the permissibility of a cyber operation, so can we conduct the cyber operation in question, would be determined by a mutatis mutandis application of the law of war principles of targeting, which include distinction, precautions in attack, and proportionality. However, I would submit that if a cyber operation takes place outside of the context of an armed conflict, or even within an armed conflict, but does not reach the threshold of an attack under the law of war, it would be misguided to subject such an operation to the strict application of the targeting principles. So, for example, even under the loose conception of the notion of attack, some cyber operations, such as the dissemination of propaganda, or operations that are tantamount to economic sanctions, would manifestly fall outside of the scope of the law of war. So in such circumstances, to insist on the applicability of the law of war principles of targeting would be misplaced and could in fact result in a reduction of humanitarian protection. So let's finish by considering the example of blocking a civilian television broadcast. Now, I put it to you that there is a general consensus that an operation consisting solely in this effect, in blocking the broadcast as such, would not amount to an attack under the law of war. Yet, if principles of targeting were to be applied to a cyber operation aiming to disrupt the transmission of television signal, of the civilian television signal, the operation would invariably fail when measured against the principle of distinction as such. However, the principle of distinction, along with other targeting principles, flows exactly from this equilibrium between the two opposing considerations of military necessity and humanitarian considerations. And so once these underlying driving forces of the law of war are taken out of the equation, the reliance on the principles may actually result in overall detriment. After all, if you think of, for example, the NATO bombing of the Serbian state-owned TV station in Belgrade in 1999, we saw that the alternative way of neutralizing a communications facility would, even if it did pass the distinction and proportionality stages, likely result in more human suffering. Because as it is well known, 16 people perished in that incident in Belgrade while the TV station was off air for mere 6 hours. So in that sense, cyber operations below the threshold should not be automatically subjected to principles that have evolved in a different normative context and which reflect the specific aims of the law of war. And so, in summary, for these teleological reasons, such principles should not migrate from the vanishing point towards the core. So, to conclude, my argument consists of 3 steps. First, I argue that a systemic shift has taken place, by which the regulatory focus has moved from the law of war towards general international law. And the better understanding of this trend alleviates our fears of fragmentation of international law, and it also improves our understanding of, if you will, the periphery, the vanishing point, and the core, or in other words, the relationship between the law of war and general international law. Secondly, this trend has allowed for specific concepts to migrate from the law of war, where they had originated, evolved, or consolidated, and to influence other areas of international law, and we have seen this on the example of the functionality test. But thirdly, it is imperative that we take the unique teleological underpinning of the law of war into account before we accept that its rules and principles should migrate, should be transplanted into other normative contexts. Thank you very much for your attention.
So I will use this opportunity to ask the first question, actually, because I was interested in the term that you used, militarization, militarization of cyberspace. In our work at the CCD-COE, we follow what various international organizations are preparing. And we know that some countries like China or Russia, they like to refer to this militarization of cyberspace. And to me, it seems that they are trying to sort of avoid accepting the idea that international law really does apply to cyberspace. So what's your view on this divergence in concepts and understandings of the
Okay,
countries?
so the question is about militarization of cyberspace and the different approaches that we have. So it's also builds, I think, on what Sean was talking about, different approaches that we have between the West and other countries. It's difficult to say. I don't like it when people say the East, because obviously the other cyber superpowers like China and Russia often take different positions, although they sometimes coordinate between themselves. But it's a very interesting question, and it's something that, together with Professor Zhizhong Huang, who will be known to the CyCon audience because he was presenting here 2 years ago, if I remember correctly. So we have a research project that looks exactly at that. So the different approaches to the international rule of law in cyberspace, and one of it's an article that's coming out now in the next edition of the Chinese Journal of International Law, and one of the sections looks precisely at militarization. So basically, the central argument of the piece is that there are certain areas in which the West and China seem to be, at first glance, moving apart, but then when we dissect their individual positions, we see that there is a certain trend of convergence. And so, you know, in one way, how we see that, just to give you one example, because yeah, I see that we're running out of time, but just one example is the Tallinn Manual itself. Right? So think of the first Tallinn Manual, which, as Mike said earlier on during his interview, was maybe criticized to some extent for the lack of geographical representation. So already the second edition not only had a Chinese expert, so who was the same, Professor Huang, it so happens, but also the views of China as such were represented through the so-called Hague process. So the conclusions of the Tallinn Manual, of course, are not reflective of any of the government's positions, but they can be seen as taking these views into consideration. And remember that the criticism that there is a militarization of cyberspace through this regulatory focus was based on the fact that a lot of Western countries were just looking at it purely through the law of war lens. So already by expanding the scope of the Tallinn Manual, I think this criticism is, if not brushed away, then at least significantly weakened, I would say. I hope that answers the question.
Of course, thank you.
If I may add one thought as well, I found it very interesting that when the Chinese diplomats were posed with the legal question of does international humanitarian law apply to cyber conflicts, their response was a very pragmatic and practical discussion of militarization of cyberspace. So going back to the fact that there's an interplay between military security concerns, legal development, etc., that they didn't respond with a legal argument.
That's right. And so, I mean, I would just add that remember that China is also represented on the UNGGE. And so in the 2015 report, and again, we have heard that it can be interpreted in a number of ways. So it shies away from saying IHL applies to cyberspace, but the report does mention a number of principles, some of which I have just spoken about, as being applicable to cyber operations, distinction, proportionality. So this language is there. So if you want to see it, China has subscribed to that view already. And yeah, so for more details, I'm happy if someone is interested to send you the article before it comes out. But yeah, we did look into this, and it's really, I find it a fascinating area of the law, absolutely.
I think we have time for one more question to this presentation. The gentleman over there.
My name is George, student of Glasgow University. My question is, I'm a bit confused. So, do you think that blocking TV broadcasts leads to applicability of international humanitarian law or not? So, because if yes, what are the consequences? And if not, what is the point of talking about it?
Okay, so the question is, does IHL apply to the blocking of civilian TV broadcasts? That's the question. That's right. So yes, I believe I'm not putting forward any lex ferenda, any de lege ferenda analysis. I am solely focused on this migratory, whether we see this migratory pattern or not, and then how is it blocked, but perhaps by these teleological considerations. So I believe the answer in law is clear. If we have a situation of an armed conflict, IHL applies. And then if the sole effect of an operation is to block the broadcast, or jamming of the broadcast as such, then this would be outside, this would not be seen as an attack. So I think that's the answer in law. But then the question is, and that's what I'm interested in for the purposes of this paper, why is that so? And My argument is that it's because of these underlying considerations of military necessity and humanitarian considerations. And I don't know if the book has the book been distributed to all the participants?
Yes.
Okay, so if you look at the book, look in the book, I discuss the scenario in detail, and I compare digital and kinetic attacks against broadcast of this kind, so you can find more information about the argument in all of the steps.
Okay, thank you. So let's keep some questions for Kubo to the end of the session. Now let's turn to the third topic of the session, which is attribution, a very elusive topic, not only from the legal perspective, but also from the actual technical viewpoint. Peter Stockberger looked at the current state of the law and also at some recent cyber incidents, and he wrote a great article on possible developments in attribution. He observes that there might be a new rule on attribution coming into existence based on states' reactions to these incidents. Peter is a senior managing associate with Demptons, which is the world's largest law firm with high-level expertise in cyber law. He's a member of the firm's global cybersecurity group, and he also specializes in public international law and serves as an adjunct professor at the University of San Diego School of Law. The floor is yours.
Great. Thanks, Thomas, and good afternoon, everyone. As the title of my paper indicates, I'm going to be talking about what Professor Schmidt has identified as the gray area of international law, attribution. When can a state be responsible for the third-party cyber operations under international law and under the law of state responsibility? And my proposal, my theory, is that there is a new test developing through state practice that is arguably lowering the standard for that type of attribution below what's known as the effective control test. So before I get into that theory, I think it's first important to just talk about the basics of state responsibility, the basic framework, what the basic attribution tests that are out there currently understood under customary international law, and then talk about the state practice that I believe is formulating the new test. So the law of state responsibility is pretty straightforward. It really only has two elements. One, there needs to be an internationally wrongful act, and two, you have to figure out who did it. And the key for the purpose of my paper is on the who did it portion. When can it be attributed to the state? And that's when you have state responsibility. And we see that clearly reflected in Article 2 of the Articles on State Responsibility. And so that first element is the action attributable to the state? That's the focus of my paper. In terms of the basics of when a state is responsible for certain actors, there's really three situations in which the state will be responsible. The state's responsible for the acts of their state organs, for their de jure de facto state organs, and then they're able to be attributed to third parties. And there's different tests for each three of these categories. And so the focus of my paper is on the third category, which is third-party attribution of third parties who are neither a de jure nor de facto state organ. So it's that third category. And we can see these three categories reflected in the Articles on State Responsibility. Article 4 talks about the organs of a state. It also talks about the de jure state organs. And Article 5 talks about de facto state organs. The article that I focus on is Article 8 of the Articles on State Responsibility. And this is the test, the general test for attributing the actions of a third party to the state. And the language in Article 8 looks at whether the third party was acting on the instructions of or under the direction or control of that state. And so Article 8 is written in the disjunctive. And Kubo has a paper, I believe it's called Deconstructing Article 8. And so there's a heavy debate over whether these are disjunctive or conjunctive terms. But for the purposes of my paper, I accept that this is the test operable under Article 8. So that frames the attribution question in cyberspace. So the question is, under Article 8 as the general test, when is a state internationally responsible for internationally wrong cyber operations of a third party who is neither de jure nor de facto state organ? And that is an extremely difficult question to address in how the law applies to cyberspace, because as we can see, attribution is very difficult, and it's very difficult because of this effective control, this direction and control test. Because there are a number of risk factors associated with attribution. There's a diversity of actors, they have different motives, there's often sometimes destabilizing motives. In the recent disclosures from the shadow brokers show that states have the capability to create false flag operations to make it look like another state committed the act. So attribution is really fraught from both a practical and a legal perspective. But this general test under Article 8, this direction or control test, I want to break that down a little bit further and talk about the different levels of control that certain tribunals have interpreted Article 8 to include, and then look at the state practice that I think is perhaps changing those tests. And so the two tests we can generally see are the effective control test and the overall control test. The effective control test, the origin of it is the 1986 decision from the International Court of Justice involving Nicaragua and the United States. And in that decision, the court was examining whether the United States was internationally responsible for the individual actions of the Nicaraguan Contras, in addition to whether the United States was internationally responsible for simply engaging in the acts it engaged in itself. So there were two questions the court looked at. And the court essentially said that the United States is not internationally responsible for the individual actions of the Contras because the United States did not direct each element of the Contras activities. And so there was a missing factual element to show what the court said at the time, complete dependence, which that test has subsequently been sort of mitigated or softened from complete dependence. But it really looked at, did you control, did you direct? And that was the determination by the court, that they were missing the evidence of direction by the United States. And so scholars determined that test to be called the effective control test. We fast forward to 1999, and the appeals chamber of the International Criminal Tribunal for the former Yugoslavia, in its Tadic opinion, looked at whether to use the effective control test in determining the existence of an international armed conflict for the purposes of triggering the Geneva Conventions. And the court, in that decision, rejected the effective control test and instead adopted what's known as the overall control test. And the court essentially said that even if there is no evidence of request or direction by the state, if the entity, the hierarchical controlled group, is under the overall control of the state, there will be state attribution. And so that deviated from the effective control test. Once we go forward to 2007 in the Bosnia genocide decision, again by the International Court of Justice, the court rejected the overall control test and went back to and reaffirmed the existence of the effective control test as the operative test under international law for determining attribution for third-party actions. Now, there's some debate that was a highly controversial opinion. There's extensive debate over whether the overall control test still applies in the humanitarian context. But for our purposes, the effective control test was reaffirmed by the court and is deemed to be reflective of customary international law as the general principle, as the lex generalis, on attribution for third-party actions. And so we look to, what do the Talon manuals say about effective control? Well, the most important aspect of Talon Manual 1.0 was reaffirming that the general principles of international law do apply in cyberspace. So we know the general rules of attribution will apply. But again, the question is, and we've heard it repeatedly at the conference, is not does it apply, but how does it apply? And so the first manual indicates that Article 8 of the Articles on State Responsibility is reflective of customary international law, is the general test. And we go back to Article 8, and Article 8 talks about direction control. So that tells us that effective control then is reflective of custom, and overall control necessarily may not. Now, in the commentary to the Articles on State Responsibility, the ILC does give some credence to the overall control test as a level of control question, but really effective control is seen as the operative test, and that's what the first manual endorses. When we look at the second manual, or not the second manual, but 2.0, Rule 17 directly adopts Article 8 as the effective control test. And this is a quote out of Rule 17. It says, "A state is in effective control of a particular cyber operation whenever the state determines the execution and course of the specific operation and the activity engaged by the non-state actor is an integral part of that operation." So we have a direction, we have control, we have a direct involvement by the state as the general test for attribution. And that's well accepted. The manual also identifies what the courts have identified, which is general support and encouragement is not enough on its own. The provision of malware alone is insufficient. That's not going to be enough to satisfy the Article 8 test. And financing, organizing, training, supplying equipment alone is not going to be enough. Now, whether these in combination with one another and some additional evidence may be enough, that's a factual question. But this sort of sets the table for what the general rule is, the lex generalis, which is the effective control test under Article 8. So what my paper looks at is, I hypothesize that there is a developing lex specialis through state practice that is supplanting the effective control test in state attribution. So what is lex specialis? And a few of my co-presenters sort of hinted at it. Article 55 of the Articles on State Responsibility, which Article 8 is the effective control test. Article 55 says that the Articles on State Responsibility do not apply if a special rule of international law is developed and applies. And that principle is derived from the more general maxiom that it's lex specialis, forgive my Latin, derogat lex generalis, is the specific governs over the general. And that's an age-old principle going back to Grotius, going back to de Vatel, who have opined about when there's a specific, it governs over the general. So what does that look like in practice? Well, if we look at the 1996 advisory opinion on the use of nuclear weapons by the International Court of Justice, they looked at the application of the lex specialis doctrine. And in that decision, the court looked at the application and interpretation of Article 6 of the International Covenant on Civil and Political Rights, on the right to life. And the court said that you need to interpret Article 6 in conjunction with humanitarian law, the law of war, which is the specific law, which is the lex specialis. And so in this instance, the court actually merged the two. They said you don't displace the general law, which is the human rights principle, Article 6. You actually have to interpret them together, because the lex specialis needs to be used to interpret the lex generalis. So that's an example of where they work together. An example of where the International Court of Justice didn't apply a lex specialis doctrine was going back to the Bosnia genocide decision of 2007. And in that decision, the court rejected the argument that because they were dealing with the crime of genocide, a crime of such extreme gravity, that the general effective control test should be supplanted, should be used in favor of the overall control test. And the court rejected that and said that unless there is clear lex specialis displacing the effective control test, they're going to apply the effective control test. And so this really sets the stage for what my theory is exactly what the court said. If you have lex specialis that displaces the effective control test, then that may be sufficient to have a different test for attribution. The court said, not enough evidence here in this case, we're going to apply effective control in this case, but that doesn't mean a different case couldn't come about. So that's sort of the starting point for what I think is a developing state practice. And that sets the stage for this question of effective control is the lex generalis. What is the lex specialis? And I propose that state practice since 2014 in public attribution of third-party cyber incidents to the state have not applied a strict application of direction and control. They've actually gone to a different standard, which I call the control and capabilities test, which looks to a number of factors, which include motivations, capabilities, geographic similarity, and also language. Not necessarily direction or control. So pre-2014, we know the story. No public attribution for the attacks on Estonia or the attacks in Georgia. No actual formal attribution of Stuxnet, although we know the Operation Nitro Zeus was disclosed and not necessarily rejected in the New York Times, which, we put the pieces together publicly that there may be attribution, but no formal attribution. The closest we got pre-2014, I would say, to a public attribution was the Mandiant report on APT-1, which attributed certain acts to the Chinese state. And the DoD's manual in 2013 references that in a few sentences. It's not an express endorsement of the Mandiant's conclusion, but that was the closest we got to that sort of public attribution at that level. The first example is the Sony North Korea incident, which was surrounding the release of this amazing movie, which I'm sure you all saw, called The Interview. I think it got like 6% on Rotten Tomatoes. which I'm sure somebody probably hacked into the Rotten Tomatoes for that score. So Sony, you guys all know the story. The attack happened in November of 2014, shut down Sony systems. Sony's CEO ended up getting publicly fired for certain emails being disclosed. And in December 2014, the FBI issued a memo, essentially, publicly attributing the attack to the North Korean state. And Sean and I chatted before the conference. Sean was involved in that decision-making. But the public statement on attribution here by the FBI was, the FBI concludes the North Korean government is responsible. What does the FBI say leads them to that conclusion? These technical indicators that there are links to malware known to be North Korean malware, that there's an overlap between the infrastructure, that there were several IP addresses known to be North Korean IP addresses, that there were tools, similar tools used in an attack on South Korea. Missing from this public statement is any statement of direction or control by the North Korean state. Does that mean there's not evidence of direction or control? Maybe there is, and maybe they couldn't disclose it publicly, but this is lesser evidence, yet there's a public attribution to the state. Another example is in the recent indictment of the 7 Iranian individuals by the former Attorney General Loretta Lynch. And in that indictment, they indicted the 7 individuals for attacks on U.S. financial institutions, as well as their attempted access to a dam in upstate New York, which would have been an attack on critical infrastructure. And in the indictment, the Attorney General's office discusses the Iranian government's responsibility and these individuals either working on behalf of, based on the scope of their capabilities in the attacks. They talk about ties to the Islamic Revolutionary Guard. They do not describe instruction. They do not describe direction. And instead, they talk about one defendant receiving some credit towards a military course. And it's sort of when you piece these together, then there's a conclusory statement about, well, the Iranian state is also responsible for these actions. Now, that's not necessarily a public formal attribution, but it's the US government, through the Attorney General's office, making a public statement. You can debate whether they have the authority to make that statement, but that was a public statement. The Russia-US election interplay is probably the most significant example of this. We know the history. APT 29 and 28 entered the DNC computer systems in 2016 and 15. CrowdStrike issued a report in May 2016 identifying these two groups. We had the Guccifer 2.0 disclosures in June of 2016, and then CrowdStrike issues their Bears in the Mist report in June of 2016, formally identifying these two groups. Now, CrowdStrike doesn't necessarily say this is the Russian state, but they certainly imply that in the report. The attribution it starts to come in October of 2016 when the FBI and the Department of Homeland Security issue their first release on the attack. And they indicate that the US intelligence agency, 17 agencies, have high confidence that the Russian government, now they say directed, but the evidence they use to show direction is methods and motivations of Russian-directed efforts. So they look at motives and capabilities and methods. They don't, at least publicly, talk about direction or control. And you see the listing is, the motivation was, well, the thefts were intended to interfere with the US election process. They say it's a similar tactic that Moscow had used in other European activities. And they say based on the scope and sensitivity of these efforts, Russia's senior-most officials could have authorized these activities. Okay, that's less than direction or control publicly stated. The FBI DHS Joint Analysis Report issued later in December likewise talks about the attribution, and they indicate that they rarely do indicate public attribution in these reports, but they did so based on technical indicators. You look at the DHS DNI January 2017 report on the same case, and in that report, they identify how they look at the assessment of attribution from a US governmental perspective. And they talk about it's a series of judgments, including the perpetrator's motivations, likely perpetrator, and they talk about whether a foreign government had a role in ordering or leading. But all of the public statements the US has made on this front have not disclosed direction, ordering, or leading by the Russian government. They've been less in the public statements. And again, we were talking about the public statement, I think, is what's important for determining state practice, not necessarily whether there is secret evidence available. We see a similar trend with the Yahoo breach and the Yahoo indictment. They linked the individual criminal hackers to the Russian state based on the motivations of the criminal hackers, that the information taken was of predictable interest to the Russian state. They looked at the geographic location. They looked at the ability of the Russian state to prosecute these individuals and their failure to do so. Again, nothing of direction or control, but instead methods, capabilities, motivations. Finally, I think that the presidential election in France, there's been large-scale public sort of assumptions that APT 28 is the likely perpetrator. If we go back to the DNC hack, APT 28 was identified. If the French government identifies with the same public analysis that the US government did, that would be another example of a state endorsing a lesser standard than direction or control, but we don't know what the French government is publicly going to say. They're still investigating this attack. And the WannaCry is probably the latest example. We have evidence publicly of private companies like Kaspersky Lab and Symantec who are pointing to the Lazarus Group as the responsible actor for WannaCry. Now, the Lazarus Group was tied to the Sony attack. And so again, if the governments that were hit with WannaCry publicly state that we tied the Lazarus Group to North Korea based on similar public statements of the US, that would be less than direction or control. So just to conclude, I think the private actor attribution actions are increasing. We see a lot of individual reports that are using technical capabilities analysis to attribute. And I think there could be a trend in the future of private-public cooperation on looking at attribution because private companies are really sort of leading the charge on this. Recently, FireEye issued a report talking about APT 32 and hinting at ties to the Vietnamese state, but again, based on technical capabilities and motivations, because they were aligned with Vietnamese state interests. So the final takeaways are, I think if this test is continued to be adopted, it's going to lead to quicker attribution, which will lead to more state options once attribution is completed, but it's also, there's a risk of false flags, misdirection. I mean, if you're just relying on technical capabilities and not direct evidence of direction and control, that could open Pandora's box for a lot of false attribution. The shadow broker disclosures show us that states can manipulate attribution data, and public statements on attribution are difficult. As Professor Schmidt identified this morning, states are reluctant to come out and attribute. I think the French reaction to the election and the public reaction to the WannaCry, if there's going to be attribution, I think those will be the next steps on determining whether this state practice, as I see it, is going to continue to develop. So with that, thank you. Any questions?
Okay, so let me ask the first question. Speaking of WannaCry, how do you view false flag operations? How do they? Because in the WannaCry incident and in the leak that preceded it, there are allegations that the U.S. government has been preparing tools for false flag operations. How does it square with the control and capabilities test?
So I think the establishment of a test or of state practice is separate from the veracity of the evidence used to meet that test. And I think the false flag operations would go to whether there's a test through state practice, I think is a separate question of, is the evidence used to satisfy that test reliable? Is it substantiated? Is it corroborated? How did you come to that evidence? And the International Court of Justice has looked at that. They've talked about, here's the standard, and then they look at the weight of the evidence and where does the evidence come from. So they give little weight to single statements by state sources. They give little weight to newspaper reports that are unsubstantiated. So I think that's where the question of who was the source of it and where did we get the information will come in. Thank you.
I have a legal question, if I may. For me, one thing that I would really commend you on in this paper is that you talk about Tadic, but you don't base your argument on Tadic, because some people who are trying to reinterpret the applicable test are saying overall control is the way to go, but they forget that, that even the ICTY only held it as applicable to organized armed groups and not to loosely organized groups, not to individuals, which is what we are dealing with in cyberspace. So this I entirely agree with. But then when it comes to your proposed test, and I take it that it's just an emerging, your argument is that it's an emerging test, so we have some data points of state practice. But if you look at the legal elements of state responsibility, you rightly focus on attribution, but there is the other one. So there is also the other element, and that's the existence of a breach.
Right.
But as far as I understand it, none or almost none of the statements that you refer to, they might say that a state is responsible, but they don't indicate which primary norm of international law would be violated. And so thus, would it not be right to say that these are instances of political attribution, very interesting, but still not amounting to a reinterpretation of the applicable test of attribution?
Yeah, I think that's a fair point, and a point I sort of struggled with in the short word count that we had on submitting the papers was there is this, anytime you're looking at the development of custom and state practice, you have to think about, is it actual political, are they political statements or are they legal statements? And I think that the public statements from the US on North Korea and Russia do amount to legal statements because of the individual organs that gave the statement. I think they have the authority to speak on behalf of the US government in foreign policy in those developments. I think an argument could be made that, well, it wasn't the State Department, the president didn't make that statement, so, and they didn't mention which norm was violated. But I'm not sure that you have to specify word for word which norm is violated. I think I agree, and I think that was part of the discussion this morning, which is that is preferred, and that's the missing key right now with a lot of state practice, is you don't have, you violated this principle. It's either the principle of non-intervention or something lower, interference, or something higher like armed attack. So I don't know. I don't know yet if that sinks the theory. Maybe it does.
Yeah, I think that's a good answer.
Maybe it does.
I saw Mike Schmidt before raising his hand.
Well, I thought it was an interesting presentation as well, and I had exactly the same question as Kubo on the breach, because a statement that doesn't identify the nature of the breach, I don't know to what extent does that qualify as an expression of opinion juris. I guess my question had to do with something Kubo hit upon. Recently, the ICRC has issued its monumental commentary on the Second Geneva Convention, in which it addresses the difference between effective control and overall control. Overall control was never meant to be an attribution standard. It was meant to be used for the purpose of classifying a conflict as international, such that the law of international armed conflict applied. So that's the way IHL guys like Kubo and myself always understood it. But in the 2016 commentary, the ICRC seems to question that somewhat. What they say is they got it right with regard to overall control and classifying a conflict. But golly, I mean, if you're going to make a country go to war as a matter of law, it would seem to me that the individuals who committed the acts are acting as agents of the state. In other words, it's really weird, and they're right, it's really weird that you can have an action that would start a war between two countries, an international armed conflict, but the state at war is not responsible for the actions of those individuals. So the ICRC has, and I don't know what I think about this yet, but the ICRC has suggested that perhaps the right test for attribution is in fact overall control. So I was wondering if you thought about that at all, because that would almost seem an easier course of action, because it's already in play, this concept is out there. Particularly since, with respect to the emergence of a customary norm, the crystallization of such a norm, your examples are limited to particular states, or like-minded states, if you will. I mean, so we might think the French are a lot different than us, but they're not. And so that limits the persuasiveness of the notion that we see a customary international law norm in the process of emerging as a lex specialis.
I totally agree with that, and that's why I say I think it's arguably emerging. I think we need much more state practice. I think the French reaction is going to be interesting to note. I think for the WannaCry attack, that'll be even more interesting because it hit more countries. And so if we see more countries come out and publicly attribute the attack to North Korea, I think I agree that states should come out and say that was a violation of X, Y, Z principle of international law to satisfy the second element. But in terms of satisfying that first element of state responsibility, I think it'll be interesting to see that more state practice. I agree the overall control test would be easier to satisfy. I do tend to agree with the ICJ's analysis, though, on the genocide decision, where they say overall control stretches the concept of state responsibility too far. I mean, it really doesn't go to the core of the state is the one supposed to be handling each element, and I think that's the part that I sort of struggle with. Was I agree that effective control is the standard. I think that they're developing a lower standard in this specific space for this specific reason, instead of saying, well, overall control is the standard generally, because then you get into an argument of does it supplant effective control generally, which is the lex generalis, and that part I'm not sure. I think the question is, what will state practice show? Will states start adopting the overall control test in the language, or will they go towards a sort of just publicly looking at, well, the malware is similar. And this is the stuff we can publicly talk about because private companies have already talked about it. Meanwhile, there's probably secret evidence that has much more solid ties, but they're not going to disclose it because they don't want to disclose their methods and capabilities. But I think that's definitely, in terms of just what I'm looking at, those are the core questions.
We have about 5 minutes left, so let's take questions to all the speakers. Gentleman in the front row.
Thank you for the presentation. My question is, the practice of Security Council is a bit different from the case law of ICJ since 2001, and a particular operation in Afghanistan. There was another kind of attribution, right? There was a lower kind of attribution in order to invade the terroristic group. So what do you think this is, how it can influence your approach or at all? And what do you think about enable or unwilling test, if you are familiar with that, when the state is tolerating, is not directly participating? So do we really need to attribute the actions to the state? Thanks.
Yeah, so the Security Council resolution in the U.S. action where they said the Taliban regime is responsible for the attacks on 9/11, therefore we are triggering Article 51. I note in the paper that that's sort of this outlier deviation from the attribution test that we know, based on a sanctuary model, based on, well, you knew what they were planning, you could have controlled it, which really, to me, goes more to the due diligence principle and the duty to prevent, which is not an attribution standard. That does not say you are responsible for the actions of al-Qaeda. It says you are separately internationally responsible for failure to prevent, to exercise due diligence. And we see that in the environmental context, with the precautionary and preventative principle debate. And it's not about the final act itself, but it's your failure to prevent. So I think that's probably the more proper model to apply is the duty to prevent model, which I think you can see in the 2.0 manual talks about the duty to prevent is another gray area. But I think that's I don't know if that was the correct attribution application in that case. And I don't think it would be a workable model to say sanctuary states are internationally responsible for the individual cyber actions of third-party actors in their state if they don't control that infrastructure. I think that's an even more unworkable standard than overall control. I think you instead can have two prongs of responsibility. One, under a more effective control or lex specialis test, and then second, you're responsible for failure to prevent. And so if you brought a state to the ICJ, you could have two theories of liability.
It's failure to stop, not failure to prevent.
Right.
You have to be very careful,
Right.
especially in cyber context.
Yeah, and that's a good point. There's a difference between failure to stop and failure to prevent. And in the other legal frameworks where the prevention principle is applied, there's an ongoing debate on how early, what level of action you have to take. And I think all of that nuance is still needs to be fleshed out in the cyber context. But yeah, excellent point. So which test?
Enable or unwilling is a quite new concept.
Right.
Which means that the state don't want,
Right.
or can't fight that.
Right.
So I just thinking about the perspective when the non-state actors acting from the territory. Do you
Yeah, I think that sort of model goes to the articles on state responsibility talk to omission or actions. So the idea of an omission is also part of state responsibility. And you see that theory being played out in the joint criminal enterprise theories in the international criminal tribunals, where someone is in a position of a control or authority, and they fail to take action, even though they have the power to take action, and they have knowledge of the internationally wrongful act taking place. And so, I don't know, that's criminal law. That's sort of taking an aiding and abetting theory of liability, and whether you apply that into the sort of civil realm of international law, I think that's I don't know the answer to that, but that's where I would see the separation.
Laurent Giselle, or?
Thank you for the very interesting presentation. Laurent Giselle from the International Committee of the Red Cross. Just reacting to Mike's point on the commentary that we published and that the ICRC published, and the fact that we see overall control also for responsibility. Actually, that comes back to what the ICTY did, even if everybody sees it as an attribution for classification. Cassese explained in an article in the European Journal of European Law or something like this, that it was actually the test of responsibility that the ICTY used in the first place. And that makes total sense. As Mike mentioned, if you have a party, a state who becomes party to the conflict because of overall control, and then no act can be attributed to that party to the conflict, that's totally incoherent with the notion of being a party to the conflict and with the law of state responsibility. So the two tests must align one with the other. I mean, classification of country and attribution to the parties to the conflict. Thank you.
Yeah, was that a question? Oh, okay.
Yeah, I'm happy to quickly react. So I agree entirely, Laurent, although I am in the camp which sees the difference between the effective and overall control still. I still believe that one is more appropriate for attribution under the law of state responsibility and the other one is more appropriate for conflict qualification. But I would again reiterate that for the purposes of this debate, when we are talking about cyber operations, when we say A, we have to say B, and Professor Cassese says it in his European Journal of International Law article. It's also there in the ICTY, although it's buried because the appeals chamber was not entirely clear. But it's, I mean, if you read it carefully, you see that the overall control test is only supposed to apply to organized armed groups. This is also what the ICRC says in the commentary to Common Article 2, the new commentary. And so, name me one organized armed group. I mean, we already have problems using the law for lens, was my argument today, in looking at any of these cyber operations. But even if you take it, as you argued with all the qualifications yesterday, that perhaps the Ukrainian conflict could be seen through this lens, perhaps the Georgian conflict is another one, show me an organized armed group that's operating in cyberspace. And so the ICTY rightly limited the effect of the overall control test to that, to those circumstances because an organized armed group has this military discipline inside it. And so we can use a test that is slightly more loose than effective control, but we still have to use the test of effective control for all other situations. So all of these loosely organized, Cyber Berkut and Cyber Caliphate and the Anonymous, they do not meet the criteria of an organized armed group. So still we have to fall back on the effective control test, unless, of course, Peter convinces us that we have a new test that has emerged. But overall control, to me, is not the answer.
Okay, one last question.
Okay, my question will be very short. What about the Saudi Aramco incident? Is there any statement, like any reaction from Saudi Arabia on that point? And do they confirm your theory or not, in case there is a statement?
I'm not aware of any public statement by Saudi Arabia attributing the Aramco incident to a nation state or for any reasons why. I think if there is a statement, to me, it's what the statement says. What do they say is the reason why the state is responsible? And so, you go back to the Sony incident, well, the United States said these technical indicators are why we are reaching this conclusion. None of those talk about direction or control. So if Saudi Arabia came out and said, we have evidence of the X state directed and controlled this activity, we are attributing it to this state, this violates X, Y, and Z obligation, I think you'd have new state practice in that area. But again, there's just little state practice on public attribution, and that's, I think, what everybody's waiting for is more state practice so these norms can sort of come together a little bit better.
Thank you. Let's not cut the full coffee break short. Thank you for the presentations. Thank you for the questions, for the answers. Thank you, Karen.